So thank you so much for the opportunity to present my work here. It's really such a privilege to be here and to participate in these discussions. The conference has been really an incredibly exciting experience for me, not least because of the constant sensation I have that all my footnotes have come alive. But as a newcomer to the conference and to the Originalism discourse in general, I thought I'd just explain a little bit about the background to my paper and how I came interested in these debates from a comparative constitutional law perspective. My previous research focused on constitutional rights adjudication in developing democracies in Southeast Asia. And while carrying out this research, it was then that I became intrigued by how frequently and forcefully judges, lawyers, scholars, and commentators would make originalist arguments both inside and outside the courts in Malaysia and Singapore. I became even more intrigued after turning to the vast literature on originalism and noticing that one dominant theme seemed to be this idea that originalism was a distinctly American preoccupation. So by telling the story of originalism in these two unexplored contexts in Southeast Asia, I hope to at least add a little bit of nuance to the story of originalism both here and abroad. So the standard narrative, we are told, is that originalism does not thrive outside the United States. Some comparative work has been done on Australia, Canada, and recently on Turkey, but Malaysia and Singapore, I think, add two new examples that have not been explored before to an emerging discourse on whether and how originalism thrives abroad. Originalist rhetoric has hugely popular appeal in Malaysia, where it's frequently employed to push for expansive constitutional interpretation, and the Singapore National Court recently relied on originalist methods to decide on the constitutionality of the death penalty in a high-profile decision. Malaysia and Singapore, I think, present quite a unique dual case study on the use of originalism. The post-colonial countries both share a common founding as an independent nation, but both have since separated and have developed as separate and sovereign nations. They both have common law legal regimes based on the British legal system and judiciaries with the power of judicial review, and both have written constitutions with explicit Bill of Rights. In Malaysia, the story is that originalist arguments are frequently invoked in heated constitutional debates over secularism and the establishment of Islam in the constitution. This debate centers on the constitutional declaration that Islam is the religion of the federation. Secularists and Islamists on both sides of this debate constantly strive to mobilize originalist arguments to support their competing positions on whether Malaysia was founded as a secular state or an Islamic state. Initially, the Malaysian Supreme Court used an original intent approach to affirm the secular basis of the Constitution in a landmark 1988 decision where it concluded that the framers had intended Islam to have a purely ceremonial role that did not affect the legal basis of the nation's laws. But growing Islamization over the last 20 years has really changed the tone of originalist language in the country. Islamist supporters have increasingly mobilized originalist rhetoric to promote judicial expansion of Islam's constitutional position, to prioritize an Islamic interpretation over rights, most prominently religious freedom. Judges in apostasy cases strikingly have ruled that Muslims do not have the freedom to convert out of Islam, arguing that the original understanding is that Islam is meant to be the main and dominant religion of the state, and any other interpretation would result in absurdities not intended by the framers of the Constitution. In response, the secularist position is that Islam's position was never intended to override any of the rights explicitly conferred by the Constitution, and they push instead for a generous and purposive rights interpretation approach that would implement the framers' true intent. What is striking, I think, is that advocates of these contrasting constitutional narratives both claim that it is their position on Malaysia's Islamic or secular identity that is supported by the original understanding. What is also striking is that originalist rhetoric is not linked to judicial restraint of any kind. Instead, it is associated with pushing for constitutional change and judicially expansive constitutional interpretation. And finally, I think another feature of originalism in Malaysia is that it has hugely popular appeal. It is not confined to the courts alone. Judges, lawyers, scholars, politicians, the public, the popular media frequently use originalist arguments in public discourse. Across the border in Singapore, Singapore's highest court recently used Originalism in a 2010 decision on the constitutionality of the mandatory death penalty. Yong was convicted of trafficking several packages of heroin and sentenced to death. This is a problem in Singapore because it has a mandatory death penalty for drug trafficking. And Yong argued that this mandatory death penalty was an unconstitutional violation of the right to life guaranteed by the Singapore Constitution. The Singapore Court of Appeal unanimously upheld the constitutionality of the death penalty, and they reasoned that the lack of any explicit textual prohibition against inhuman treatment in the Singapore Constitution meant that the framers' original understanding of the right to life could not have prohibited inhuman punishment. The court emphasized that the fact that such a prohibition had already existed in the European Convention of Human Rights at the time the Constitution was drafted meant that the framers' omission to include it was deliberate and not due to ignorance or oversight. So Singapore's originalist approach appears to bear little resemblance to the originalist appeals across the border in Malaysia. It seems to be more focused on text, it's constrained by precedent, it's used in a manner deferential to the legislature, and it's used very much in a manner to restrain judicial expansion of constitutional rights. The Chief Justice said in the judgment that for the courts to find an implied prohibition against inhuman punishment would be to legislate new rights into the Singapore Constitution under the guise of interpretation. The Singapore court's originalist methods also have little popular salience outside of the courts. Political and social actors rarely, if ever, appeal to the constitutional framers in public debates. It seems that it is employed in a manner slightly closer perhaps to the Australian High Court judges who have sometimes used this, in that it seems to be employed in a much more textualist, originalist manner in line with a sort of prevailing legalistic interpretive approach. So what do these comparative case studies tell us? My project is primarily about the use and practice of originalist argument in constitutional practice in these different cultures. As such, I think the paper approaches the originalism debate through a different perspective from many of the others in the room, and it's not meant to engage fully with the normative debates about originalist theory. Rather, my comparative account tries to understand how and why courts in different contexts actually use originalist or historicist argument in constitutional practice and to what ends. So I think first, these examples do show us that originalist argument plays a larger role outside the United States than previously thought. These two new examples also add to an emerging literature that has recently burgeoned on comparative originalism. Existing accounts have so far tried to explain the origins of originalism in various ways. David Fontana, for instance, argues that originalism is typically associated with a nation's revolutionary constitutional traditions, while Ozan Varol asserts that it's linked to a political leader's cult of personality, like Mustafa Ataturk in Turkey. The examples of Malaysia and Singapore, though, complicate the story so far. Singapore does not have revolutionary constitutional beginnings, and neither Malaysia nor Singapore venerates their constitutional framers in quite the same way as the United States or Turkey. Second, I think this reinforces the view that the practice of originalism is context-specific and culturally contingent. Some countries are originalist, some are not, some are somewhat originalist, and some countries that are originalists are not all originalists in the same way, and they may become more or less originalist at different times. I think that the reason whether and what form originalism thrives in a nation appears to depend somewhat on its cultural and social environment, and is often also connected to a temporal, political, or historical element. This perhaps reinforces the view of Jamal Green and others that originalist argument is perhaps best understood as an argument about constitutional ethos. Originalism has such appeal here in the United States because it is so deeply connected to a narrative about American national identity and constitutional traditions. Similarly, I think secularists and Islamists in Malaysia and Turkey battle so deeply over the original understanding of constitutional provisions on religion because it is in essence a struggle over the nation's identity. Finally, these observations might, I suggest tentatively, help us to think more generally about the role of originalist argument both inside and outside the courts. It seems that in cultures where there is a significant attachment to the Constitution, originalist rhetoric has a popular dimension within the broader societies that appears sometimes to have implications for how the courts might employ originalism in practice. The use of originalism in Malaysia and Turkey, for instance, is certainly not associated with a rhetoric of restraint of any kind, and is frequently, in fact, criticized for not for expensive and sometimes called activist decisions. And finally, the comparative perspective might help us understand why particular types of originalist methodology are attractive in certain countries. Original textual meaning type originalism seems to be favored when it is used in Singapore and Australia, in line with sort of the general legalistic interpretive approach of both these countries, whereas in nations where originalism has popular appeal, such as Malaysia and Turkey, original intent and historicist-focused originalism tend to thrive, perhaps precisely because of its role in linking constitutional history and national identity. I'll stop here, and I look forward to your comments and questions.